After reviewing both sides' arguments and the facts of this case thoroughly, in the case of Zillian Hahn versus Susanna Robertson, I must rule in favor of Ms. Hahn in that I find Ms. Robertson guilty of wrongful termination. However, I do not find Ms. Robertson guilty of invasion of privacy. To address the privacy claim first, in the private sector, there is no reasonable expectation of privacy like there is in the public sector. Therefore, Robertson acted well within her rights, monitoring her subordinates' company email at New Millennium Toys. I suggest that the company review its privacy policies to clarify its position on privacy to avoid any future allegations. On the count of wrongful termination, it's clear New Millennium acts well as an at-will employer. However, this doctrine does not give the employer the right to violate public policy standards and retaliate against its employees for doing what public policy endorses. I do not see any substantial evidentiary support for Ms. Robertson's two other claims for firing Mrs. Hahn. However, I don't actually believe that the plaintiff even violated the non-disclosure agreement by discussing product details of the Wild Things Jungle Gym with her attorney, the third party, because the public policy exception applies in this case. This is yet another example of an employer retaliating on a whistleblower who is justified, which is why such protections are now in place.